Hello, everybody. I am so glad to be able to be with you this fine spring. I'm not sure when you're listening to this, but most of you are probably listening to this as part of the CRPM program, which is a Certified Residential Property Manager. And we are hoping to inform you today about some industry changes and kind of where the legislation is going, we think, in the next few months, maybe a few weeks, if any of you are listening to this at the time that the bills are being signed. So we're going to spend just a few moments today and hopefully answer some of your burning questions about landlord-tenant changes. Once again, thank you, everybody. This is how you can reach me. And we're going to talk about the top issues. Here is what my concern is. I want you to be able to understand the hurdles that are facing both you and the tenants and all the different various agencies that are kind of watching out what we're doing and monitoring our industry. The first issue we want to talk about today is really who is monitoring the issues and what is the biggest, hottest issue. The biggest issue that I see is the application process. There are numerous groups that are concerned about how we are processing applications and the information that we're receiving and fair housing implications. On your screen, we see 5 of the ones that are currently reviewing these issues. The Department of Real Estate has some concerns. We'll talk about that. The city of Flagstaff has looked at that issue. The Arizona legislature is currently reviewing some bills that will impact this potentially. And the Arizona Supreme Court is looking at doing some rule changes that would potentially impact applications. And of course, HUD is always concerned that we're acting in a fair housing manner. So the application concerns that I see, they're really divided into 2 separate categories, Arizona categories and the federal categories. On the Arizona side, there's some concerns about disclosing the application criteria before the person actually fills out an application. There's some concerns about who's deciding and whether that person is processing that information consistently. And then if they're applying, are there actually units available versus the number of people that are applying? On the federal arena, we have some different concerns also about the application process. And the biggest one is it fair? Is the criteria fair? Is the criteria reasonable? Is it consistent? And then there's some disparate impact, which we'll talk in a few minutes. It's a little more confusing. So the first issue is that tenants are submitting their applications without knowing the rental requirements. And what I mean by that is they see this house or they see an apartment and they think, okay, this is the place I want to live. They fill out the application and they don't even know whether they're going to qualify. And while that might be a little vague, if you had a policy that said if you're in an open bankruptcy, you absolutely won't qualify, well, why would they spend the time or the money to fill out that application? And so it's our policy that a good practice is to provide the written criteria before the tenant actually submits the application. It shouldn't be a guessing game. They should know right up front, this is our written categories and our written criteria. The biggest concern, I think, is because there's a limited amount of resources that they have. And by spending, the limited money, the couple $100s that they have on 4 or 5 different applications, when 3 of those they wouldn't have qualified from the very beginning, is probably just not the best use of their resources. But also it doesn't seem very fair. I have a concern as an attorney who does this for a living that while I'm encouraging you to put your application criteria online or publish it on the back of the application, please be careful, because I'm also concerned that you're going to put bad rental criteria out there, which will now be clear evidence that you have been violating fair housing laws. So before you decide to do that, please check with an attorney and have that reviewed to make sure that there aren't any potential issues on what you're asking for and how you're processing it. In Flagstaff, there is a concern, and it's a valid concern that there's only a limited amount of housing and that landlords are taking larger number of applications than they have housing units available. So the concern is that maybe some realtor is taking 20 applications and each of those people pay $50 and the landlord only runs one of those applications and pockets the rest of that money. And that's raised a concern that the commissioner is concerned about too, besides the city of Flagstaff. There's a potential rule, although this looks like it's not going to get any traction, that they might institute a city rule that would require every landlord to be able to say at that exact moment how many units you have available Now, if you're single family homes, you know how many houses you have in your portfolio. But if you're doing multifamily, the number of apartments can change 3 or 4 times in the same day. And they also want you to make an accurate list of the number of applicants for those particular units. Well, as we all know, that can also change, especially during the school year when they're coming in. You may have hundreds of applications that all come in simultaneously. So the Arizona legislature is looking at passing a bill, sponsored, I believe, by the AMA and supported by a number of our industry participants, that would prohibit cities from creating laws or codes that implicate landlord-tenant law because it's such a statewide importance. We don't want individual cities making multiple types of laws that landlords have to now be aware of and that maybe are in conflict with each other. And if that bill gets passed, the city of Flagstaff would be prohibited from creating any kind of new rule, as other cities would be. If you're watching the national forum of landlord-tenant rules and laws, we've had some concerns that other cities, there's a city in California and a city in Oregon, where you actually have to pay your tenant if you want to non-renew their lease or if you want to increase their rent and they choose not to continue to pay that higher level rent. You have to pay them 2 or 3 times their monthly rent just to get them to leave. Those are some cities that we are very concerned about their activist policies, and as such, we really believe that the state should be controlling these types of issues. One of the other concerns about the application process is the type of questions that are being asked. Many applications ask basic questions like, what's your name? Have you ever been evicted? Do you have any pets? Have you ever been convicted of a felony? Do you have a bankruptcy? And then maybe even ask the catch-all phrase like, do you have any other relevant information? We're encouraging you to think carefully about the questions you ask and how they may not be soliciting the correct amount of information. Remember, if a tenant gives you wrong information, you can now go in and terminate that lease if you subsequently find it. But if you're not asking, then maybe they didn't lie. So if you say, what is your name? Well, that's the name they're going by now, but really you shouldn't be asking for what is any name you've ever used. Have you ever been evicted, or have you ever received a breach notice? Because if you say, have you ever been evicted? The answer is not yet. Hurry, court's next week. And aren't you really wondering if they have any breach notices from landlords? If you say, do you have any pets? No, I have no pets. I have 45 assistive cats. You didn't ask me about assistive animals. And that's why that's a better question. By the way, if you're using an AAR application, these are already covered in that particular application, which is why we encourage you to use a standardized application process. Same thing with felonies. Have you ever been convicted of a felony? Not have you been involved in any criminal activity? That's a little broader. And then having them explain that, because maybe they haven't been convicted yet. Bankruptcy? Well, just because they haven't filed bankruptcy doesn't mean they don't intend to file bankruptcy. And so a better question is, have you had any demand for payment notices from any creditors? And finally, while I like the catch-all that says any relevant information, we are encouraging you to say something like, we're offering to review anything else you think is relevant, so they can attach and are encouraged to attach that additional information. We think this is a good way to avoid some of the fair housing concerns where the information is limited. Some interesting national trends are that some states are limiting or removing or even blocking some information, credit information and criminal information from credit reports and public data reports. You've probably received this information already from your credit screening companies. That's a concern because we need to know who you're renting to. And another part of that removal or blocking is potentially creating a new rule that it is illegal or improper to ask the source of a person's income. And while I understand that cash is difficult to track, and that's not really the type of cases they're looking for. They're looking for somebody who potentially is involved in a field that other people may find undesirable, like lawyers or realtors, and they may not want to rent to that person because they think they may be more knowledgeable about the law. And so there's a movement that maybe the source of the income or what your actual job is should be a protected status. I'm not sure how much traction that will get, but we need to watch those that is a national trend. Because my concern, of course, because I represent landlords, is that the limited information that you get about who you're renting to will increase the liability that you may have rented to someone who's going to damage your owner's property, or not be able to pay their rent. And so as such, we would like to know that ahead of time. I think they ask those questions when they rent you a car, or even any kind of credit issuer. I think that that's an important thing we should all be looking at. So in Arizona, we have some legislation that may or may not get anywhere. One of those is a concern that they would like to ban employers and landlords from looking at social media or credit reports. So that shouldn't be relevant in hiring someone or from renting to someone. The move to either remove or limit that access to that type of information, including the criminal credit. Once again, I understand while they have some concerns, but if you want to look at a prospective tenant's social media, and they are clearly smoking all over their social media and maybe other substances besides cigarettes, that would be relevant before you decided to rent to them, because maybe they falsified information. This is interesting to see whether or not this will pass. It's not just Arizona, by the way. A number of different states are looking at protecting that type of information because they feel like it's not fair. You should be able to have your own private life, and the landlords and employers shouldn't be able to look at what you're doing on your own time. Another aspect of applications is who's deciding, who's looking at that information. The concern is that potentially some of those on-site staff members or people looking at that don't have sufficient training to understand what they're looking at, or potentially they have too much discretion to decide, are you going to be a good tenant or a bad tenant? Do they have a good vibe or a bad vibe? And that potentially could lead to a fair housing concern. We are also concerned that it's consistent. Are they always waiving that particular type of felony? Are they always waiving a particular problem that's on a credit report? And then the age-old issue of steering, where you look at the application and you determine this person really isn't the type of person that you want to live here, or they would be better suited for one part of your community or maybe a different community that you manage. All of the things we just talked about really are discrimination issues or potential discrimination issues. And so we're encouraging our clients to consider having a third-party screening system, somebody either who works for your company who doesn't work on site and who never met the person doing that screening, or a third-party industry, a third-party company that specializes. The real issue that I want you to think about is the person who's meeting them, are they the same person who's running the application and making the full decision? And do they know what they're looking for? Do they understand what's written in the report? Do they know that in Arizona we have different classifications of crimes that are different than other states, that one is the worst, where one may sound like it's the least? Other states have things like A, B, and C, and we don't. We have 1 through potentially 5 or 6 levels of those particular crimes. And if you don't understand that, maybe you're not the proper person to be really evaluating this particular report. Are you trained to recognize red flags? Those are things like the tenant has listed or applicant has listed that they've lived only in 2 states, but their driver's license is from a state that's not listed on an application, that they've never worked there and never lived there. Or they say they've lived in Arizona for 3 years, but their driver's license is still from another state. And our Arizona law requires that you have your driver's license converted to an Arizona driver's license after a specific period of time. Are you matching the addresses with the credit report? Are those the addresses that they list as the last known addresses? And then really, are you comparing all the other information that you received in the application against the credit report and understanding what those flags may be that may disqualify the tenant, or may just simply be a wrong indication that it belongs to this particular tenant's file? And then are you reaching out to the tenant, giving them the opportunity to clear up any apparent inconsistency? Have you ever thought about what order you check these things in? Does it matter what order? Do you always check criminal first? I can tell you that historically landlords have, because that's the fastest one to run, which is not necessarily a problem, but you need to understand the risks. What are you checking, and why are you checking those first? In our world, criminal is very important, but their previous rental history is probably more indicative of whether or not they're going to be a good tenant and pay their rent than potentially a criminal event from 10 or 20 or 30 years ago. And credit, if they've had some major emergencies like medical issues, that may not be a very good indicator, where a failure to pay the previous last landlords would probably be a better indicator. So understanding what you check and what order you check, and do you do the same thing every single time, is an important part of this discussion. Just as a reminder, if a tenant falsifies or omits material information, then it's a non-curable breach if they've already moved in. If you catch it before they are given keys, you can now terminate that lease because it's based on fraudulent information. And if they've already moved in, they're required to move in 10 days. It is not a curable violation. So you would ask them to leave. And if they don't, you would be filing an eviction action for a non-curable material falsification. By the way, one of the things we're seeing quite a bit of is that they are falsely claiming to have an assistive animal or a service animal. Arizona passed a law last year that made it a crime to falsely claim an animal was a service animal. The problem is that realistically in our housing, we're not really dealing with service animals per se. We're mostly dealing with ESAs, emotional support animals. And there's quite a bit of confusion about how does that new law impact housing. And I want to tell you right up front, it doesn't really impact our housing laws whatsoever, because service animals are allowed in common areas, public areas like airports and restaurants. ESAs are not. So let's look at a chart real quickly, just as a quick breakdown. Here's a good understanding about the difference between the types of animals. And we're talking about their classifications. A service animal is allowed in ADA laws, which is Americans with Disabilities Act. Those are public areas, airports, restaurants. In our world, in the housing world, we're really looking at fair housing laws. Now, ADA may apply in your front office. It may apply to a common pool area, but generally speaking in housing, we're talking about fair housing laws, both state and federal for housing laws. Under service animals, there's only 2 species that are allowed, canines and miniature horses. There is no species restriction whatsoever in emotional support animals. And remember, just because a person calls the animal a service animal or an ESA or a therapy or a companion, what they're calling it is not really the issue. It's really what the animal does or whether or not it's been trained. A service animal must be trained by a separate third party. It's a special process that specific agencies actually complete training and certificates. And those animals can be removed if they're misbehaving in those public areas. And an owner of a building can ask a person who has a service animal what that animal actually does and can require that it prove that it's performing a particular service. And that service would not include an emotional service. ESAs, it's a little bit different. You're not really looking at whether the animal is certified or verified to do a particular task. Your only inquiry is the tenant disabled under federal law? Does the tenant need this assistive device? And whether or not that animal's been trained by a third party or performs some very specific acts or services is not as important, because one of the things those animals can do is alleviate symptoms of a disability. You can actually evict that tenant if the animal creates a health or safety issue, the actual animal, not the breed. So if the animal was biting people or misbehaving, like going to the bathroom in an area they're not supposed to, you can actually do an eviction notice just like you would if the tenant was misbehaving. So a 5-day health and safety, a 10-day noncompliance, or even potentially an immediate. Question we hear all the time is, how many can they have and how many can they have puppies? The answer is a little complicated. I'm going to encourage you to potentially go to our website. We have a whole section on assistive animals and on issues that relate to fair housing. But the general answer is how many they can have, as many as they need to perform the services and tasks related to their disability, as long as they can have verification from a medical provider that these animals can't provide all of the service. Each one animal couldn't provide all of the services. So in general, if it's a seeing eye dog, that is trained differently than a seizure alert dog would be. And as such, they would be able to have 2 because they'd have medical providers that could avow that each animal did a different thing. It's really difficult for any medical provider to be able to avow, or that means a promise to the court, that this animal makes this tenant happy and this other animal makes them less afraid. And as such, for emotional support issues, typically one ESA would be substantial. If you have concerns about that, don't be answering that. Send it to an attorney and have an attorney complete the inquiry to make sure that you are engaging in the interactive process, which is an integral part of a fair housing question. The other issue we want to talk about, at least as to applications, is what we call disparate impact. Disparate impact is where you have a neutral rule or a neutral policy or procedure that statistically impacts a protected group differently. And if we can, for a moment, talk about the ban the box issue that came up about 3 or 4 years ago, where the Attorney General's office indicated that some reports showed that certain nationalities or certain ethnicities may be arrested and convicted more frequently than other groups, and that maybe that showed a historical or statistical bias in the criminal system, either by the police or by judges, or maybe a wealthy issue. More wealthier people have the right ability to get a private attorney, and maybe public defenders aren't as aggressive. Whether you agree with that report or not, that report implicated our way that we process applications. And I can tell you, I've told many of you personally, I think that our industry really created this problem because we had unilateral rules that if you have ever been convicted of a felony at any point in your life, regardless of how long ago and regardless of what the felony was, you could never find housing. And that created large groups of people that just couldn't, had to either live off the grid or just couldn't find acceptable housing. So the new procedure is that you are required to be able to articulate a legal reason why you have banned a particular felony for a particular amount of time and how that would implicate or create a risk for an owner. If you don't understand this policy, you really want to talk to an attorney. We have some information on our website about that. So does AAR. So going back and looking at your rules, do those rules impact particular groups statistically more often? And so let's look at a couple of those. If you're going to limit access to a common area, or say that a particular group has to be supervised by a parent or an adult, or they couldn't use a particular amenity, think about putting the word green or orange in your policy and now reading it. So something like, all green people must be supervised by orange people. And that just smacks of discrimination. So think about that. All orange people are prohibited from using the office or the common area or like a pool area at a certain period of time. So go back and look at your policies and insert a big color to determine, is this something that, if it was applied inappropriately, could raise a fair housing cause of action? Other issues like no tattoos or no piercings or facial hair, those may be statistically applied to particular ages of people and maybe a particular ethnic group or religious group. And as such, maybe you accidentally were harming a group or discriminating against a group. So we're going to encourage you to remove those from your application process. I've also seen recently some internal rules that say make sure that you have well-behaved kids. Watch the children in the office. Are they well-behaved? Are they being properly supervised by a parent? Are they nicely dressed? Is their vehicle the type of vehicle we want in our parking lots? Think about how that could be inappropriately used and potentially as a grounds of creating a factual presence of discrimination, even if you weren't aware that you were discriminating against a particular group of orange people with 7 legs from a particular country. If they have in common some of these rules or some of these prohibitions, statistically, you might be creating a fair housing violation. And I can tell you, we all agree that we need to be good landlords. It is inappropriate for a landlord to refuse to make repairs. It is inappropriate for a landlord to engage in certain behaviors or ask certain questions or violate people's civil rights. We understand that all parties have an obligation to act correctly and follow the law. We just want to make sure that you're carefully considering how those rules and laws are reviewed. We're taking a really big hit in our industry right now that landlords are evil and landlords are mean and they evict people. And as such, we're getting the knee-jerk reaction of some additional new laws that are unfavorable to landlords because maybe some landlords haven't been acting appropriately. So let's look at some potential new rules that are the Supreme Court is looking at. This is the time period where they take some public comments and they've created some subcommittees to look at these issues. And the first one is a concern of mine. There is a potential rule change to the RPEA, the Rules of Procedure for Eviction Action, that talks about adding the entire lease and all addenda to an eviction complaint. Well, that's not going to work, I don't think, because a lot of complaints, the people aren't home, so we don't hand deliver it. So we post it on the front door and mail it certified mail. Is it appropriate that we be attaching a 30-page lease to someone's front door? I think the answer would be no. If this is something that you care about, there is a place on the public comments of the Supreme Court where you can make a comment. And those of you who are in the real estate world, this would be a good use of your time. There's also a potential rule that we're looking at that would allow or provide a free attorney to all tenants at the courthouse, sitting in the lobby waiting to give them legal advice. I have a concern because that's not providing any advice to landlords. It doesn't seem fair to me that the court system would decide who's going to be a winner and who's going to be a loser. And I think that if they're going to provide legal advice, they should do it to all litigants who are there without an attorney. But that's one of the rules that they're looking at. That one's not actually up for public comment because they're just creating subgroups to look at that particular policy. They're also looking at a policy to allow document preparers to represent people in court in evictions and in lawsuits. And of course, I have some concerns because we have some advocate groups that do not follow the law and do not give good legal advice. And that particular unsavvy litigant wouldn't know that that person just committed malpractice. And they're not required to have malpractice insurance either. And so it seems like they give them lots of advice, much of which is not legal and is bad advice, and cause that person to spend a lot more time and money in the litigation process. So how do we combat that new trend? I encourage everybody to be a reasonable landlord. I see many that are not. Hopefully all of you listening to this are part of that good crowd. I think that you, by listening to a webinar to try to be the very best of your field, that probably separates you out from many of the others to begin with. And remember, just because you can doesn't mean you should. And what I mean by that is there's sometimes that you have a policy, for instance, there's no smoking policy that says no smoking anywhere on the property. Okay, well, they're in their car, in the driveway. Is that really a violation of your no smoking policy? It didn't affect the property at all. They didn't pour out the cigarette butts onto the ground. Is this really where you should be giving a breach notice? And just because you can doesn't mean that's a good decision to make. I recently had a case where there was a rule that said if you called the police, there was a fine of $150. Well, this particular person called the police because they were being beaten up by an ex-spouse. That would be an inappropriate application of an institution of a fine. That's just because they asked for police assistance when they weren't doing anything wrong. Now, if they were having a wild party and the police came out, then I would see that that's a more appropriate issuance of a fine. But remember, just because you're using a provision, think about how it's being applied to. For about the last 2 years, we've been talking about a national issue about using a provision in your lease that might be prohibited. And what I mean by that is we have a statute in the Landlord Tenant Act 33-13-15 that prohibits a landlord from including a term that takes away or limits a tenant's rights or remedy in the Landlord Tenant Act. So let me just tell you right away, the first question I always get is, well, we have a special clause that says we give up, both parties give up the right to a trial by jury. That is not listed in the Landlord Tenant Act, so that is not a prohibited term. This particular rule also says if you attempt to exculpate or limit the landlord's liability arising under the landlord-tenant law, or the same law, or you impose a penalty for summoning the police, which is what we just talked about. These are all prohibited provisions. The ones that I typically see are, and especially in single-family homes where realtors are involved, is that they write into the lease that the parties agree that during the last 30 days of the lease, that the tenant agrees with a 2-day phone call to allow access to show the property. That is a violation of ARS 33-13-43 that specifically requires the landlord to give a written 2-day notice. And by including that in the provision of the lease, you're asking the tenant to waive a right that were granted by our legislature. That would be a prohibited provision. That does not mean that the tenant can't agree at a later date to waive that policy if there's adequate consideration. If the tenant needs to move to Miami and they are trying to get out of the lease and they agree to show it as many times a day as possible with not even a phone call, you can document that process because it's good for the tenant to have those policies waived so that it can get rented quicker. We're talking about prohibited provisions in the lease. One of the ones we also see is the tenant agrees to waive a particular claim against the landlord if the landlord breaches that. The ones I see are something like if the landlord fails to provide the access to the home because the previous tenant has not moved out, the tenant agrees to not, the prospective tenant or the new tenant agrees to not sue the landlord. Well, we have very specific laws in the Landlord Tenant Act that talks about what happens when a landlord doesn't provide access to the home or possession of the home, and whether or not those are enforceable is very, very technical. So just bottom line, don't make up provisions. Choose very carefully what additional clauses you want to use, and please talk to an attorney, because the ramifications for using a prohibited term, that the tenant may be entitled to 2 months free rent for each and every single clause that is deemed illegal or inappropriate. We see quite a few landlords that are failing to forget to register as a landlord. Remember, this is not the landlord tax law we're talking about. This is a landlord registration form. Every county is required to keep a log of all the landlords, and that's a specific state statute. In Maricopa County, you can go to the county assessor and just Google landlord registration. If you fail to do this, the lease may be invalidated and the tenant may be entitled to get out of the lease with simply a 10-day notice. The law does allow you to that someone has to tell you, and you have 10 days to cure that particular breach. You would have the right to go in and fix the issue. So if you receive a notice from a tenant or from a city that you are not properly registered, even if you think you are, pull up the registration. If you have a wrong address, a wrong phone number, if you've changed your email address, you are required to go up and update that registration form. Bottom line, make sure that you stay informed about the new laws. So there's been several laws that were passed last year, so let's start with those. We changed the law regarding how we're holding tenants' possessions. Those were found in two different statutes, 33-1368 and 33-1370. They're really different types of procedures. An abandonment was when a tenant skips out, just leaves on their own. Sometimes they're forced out by a constable through a writ of restitution. We have now moved both of those sets of laws to one law, 33-1370, and now we have an exclusion. You are not required to hold any property if the tenant returns a key. That means if they physically give you the key or if they put in writing that they've left the keys on the counter. The time frames used to be 10 days and 21. They are now 14 days for both sets of circumstances. The other interesting thing to that change to that law was that an animal can be removed immediately, but it still has to be boarded or stored for 14 days. But it can go to a third party. Just make sure you're filling out the correct form. You're required to notify the tenant in writing that they have 14 days to retrieve their possessions and to tell them where those possessions are being stored and what the cost of that storage is, including the boarding. That's required to be certified mail return receipt requested to all known addresses. Some items can be disposed of immediately, by the way, if they are include bed bugs, something that's infested, or they are spoiled or ruined. You do not have to store the garbage for 14 days. Just make sure you take a really good inventory of what you're getting rid of. That is required by statute. You must inventory, and that could be pictorial inventory or videotape, but you're required to take an inventory of any possessions left behind by a tenant. There is a new law regarding security deposits. That change basically says that if you send out the tenant security deposit disposition, we call it the SODA, within that 14 business days time frame from the time frame the tenant returns possession and gives you a written demand, that disposition is deemed adequate and acceptable, and the tenant really waives their right to come back and contest those charges after 60 days. Yes, that's 60. So you really are now encouraged as a landlord to make sure you're sending that out quickly and correctly. Remember, you have to mail it to the last known address. Another interesting law that's been changed is actually a federal law. It's called the PTFA, the Protecting Tenants' Rights at Foreclosures Act. It was a law back in 2009. It's now been reinstated. That will affect our industry if you are dealing with owners that just recently purchased a home at foreclosure. The people living in the home may be protected. They will not be protected if they are the previous owner. They will be protected if they are what we call a BFT, a bona fide tenant. This is a complicated issue, so I want to encourage you to speak to an attorney about that. We have some information on our website that gives you the overview of that law. Once again, we've continued to have issues with fair housing violations, mostly because I think people don't understand what the law is. Haven't found very many intentional acts of fair housing violations, but I think that there's a misunderstanding. So I know that most of you listening to this are licensed realtors. I'm going to encourage you to take more than the minimal amount of fair housing classes. The laws change so frequently that doing it once every 3 years, which is the ADRE rules, that's just not sufficient. The rules change so rapidly. You really want to do a fair housing class every single year. And let me give you a hint. Take one from a group like AAR that has experts in that area instead of something online. The laws change so frequently that if you're listening to or looking at an online class, the chances that class has not been updated since the last fair housing law changed. So think about taking some better educational classes. I'm going to talk just for a second about the difference between accommodation and a modification. This is my catchphrase. Accommodation involves a rule, a modification requires a tool. The reason why that's important is because accommodations usually don't cost anything. And as such, when HUD says it's reasonable, you're required to grant it. But a modification, even if it is reasonable, can cost money. Putting in a grab bar, putting in a ramp. As such, HUD has said that you're allowed to charge the tenant for that modification. And that's why you really need to understand the difference between an accommodation and a modification. This is just a quick overview. If you don't understand that process, please make sure you take a good fair housing class. Every time you are dealing with an accommodation or a modification request, make sure that you document what they are requesting in writing. Once again, remember, if they can't write because of a disability, you need to waive the written requirement. That is the accommodation, the waiver of a rule. You need to verify the disability. If it's not obvious or it's readily apparent, the person didn't come in with a seeing eye dog, but they're saying that there's a vision issue and they need you to potentially do something differently with their lease, then you can ask for verification from a medical provider. The medical provider is not defined by statute, so be careful if you're deciding what medical provider you like. You may just be the test case on this particular issue. You need to participate in the interactive process. That means if you're going to say yes or no, you need to have a good discussion about what you are doing, what they are requesting, and what you are waiving. And if you're not, why you are not, and suggest an alternative. Document that resolution or why it wasn't approved. Please make sure you speak to your broker before you complete this process or speak to an attorney about it. Make sure that you have consistent policies, that you're always waiving the same thing or never waiving that, and you're always applying the same criteria. This is once again a fair housing violation that we're all looking at, that the way that you apply your rental criteria is not consistent, because Mary did it one day on Tuesday when she was doing it, and Bob, who is now looking at those applications, did it differently because they were trained differently from different groups. Make sure you have a written policy about how you do that. When do you check those? How often? And if you're using highlighters, please only use one color highlighter. Get rid of all of them in your office and only use pink or yellow or blue so that it's consistent. Otherwise, it looks like you're color coding an application. Don't waive policies for some groups unless it's disability related. What I mean by that is don't waive the late fees because you feel bad that her husband left and she's got 5 children. Because if the next person is single and a different religion, they're going to say you treated the first tenant differently from them based on their religion. And even if you didn't know the religion, statistically, it looked like you may have done that. However, please pay attention to this particular exception to the rule. People frequently inadvertently deny a fair housing request because they use the phrase, I can't do that because if I did it for you, I'd have to do it for everyone. That is true unless the request is based on a disability. It's based on a disability. That is a fair housing accommodation request. Change to a rule or policy. Make sure that you complete that process, put it all in writing, and then address the concern regardless of what you do with everyone else. Once again, talk to your broker or talk to an attorney. We want you to treat everyone fairly, but remember, fair is in the eye of the beholder, and sometimes there's specialized rules that require you to treat someone differently. One of the examples of that is the domestic violence statutes. We have those in Arizona. We also have what we call VAWA, Violence Against Women Act. It affects housing in that it protects the victim from being re-victimized by a landlord. And what I mean by that is when you have a policy that you're going to evict the tenant because her ex-boyfriend broke into the home and damaged the house or broke the front windows, you evict her for that because she's responsible for all of her guests. This particular statute says she's not responsible for someone that she did not invite over and committed an act of domestic violence against her. It's a very complicated federal statute. If you are in the subsidized arena, you've been trained on this for the last 3 or 4 years. If not, really be careful if someone alleges that they are a victim of domestic violence. Slow down this process and consult with your broker or with an attorney that understands how this particular statute and Arizona statute 331318 may apply in this particular set of events. It allows them to terminate the lease early without penalty. It does allow them to request a lock change, although you can require that they pay for that lock change. And we have a new category of a protected person is a person that is sexually assaulted on the premises, regardless if they knew that person or not. There's a new category that they'd be able to get out of their lease. One of the other hot issues is there has been a ruling in Maricopa County by one of our appellate courts that the acceptance of the housing assistance payment, we also call it a Section 8 payment, from the housing provider may be a partial payment and may prohibit a landlord from evicting a tenant if the tenant doesn't pay their portion. This is a hot issue. We're not sure where exactly it's going to go. We've now written a bill that we believe the legislature is going to pass into law and the governor will sign. But the Court of Appeals is hearing this issue in March on an appellate case we'll call a special action. So if you accept Section 8, you want to speak to an attorney who's knowledgeable on this particular issue so you can make an informed decision about what do you do right now until that law's been changed or that Court of Appeals ruling has been published. Because it may impact whether or not you continue to take Section 8, and it may impact whether or not you accept any monies from that Section 8 housing provider. So, of course, as I say in all my classes, the key is staying informed that knowledge is power and that you do what you can to stay informed. Taking this webinar is one of the best ways to do that. I wish you all luck. If you have any questions, once again, always feel free to reach out to AR or reach out to me with any questions on this seminar. And have a terrific day.